Met with the basically, my lord, by way of this PIL, we are directing and we are seeking, my lord, an inquiry by some impartial agency to inquire into the, my lord, wrongdoings committed by the respondents. Now, my lord, I have given a small compilation. If your lordships would kindly come to Ishane. Page is, if your lordship would kindly come to page 1 of that compilation, I'll just give 2-3 examples, my lord. Then your lordships will have an idea of what is going on. Now, kindly see, this is a project proposal of Dongmei Bay Gaon flow irrigation scheme. These are all part of the pleadings. Just for convenience, my lord, we have prepared this. Now, estimated amount is, my lord, 10.93 crore. Now, if your lordship kindly comes to page 2, how, my lord, they're resorting to falsehood. On the first sentence on top, hydrology, main source of water is Dongmei River, which is perennial river. Well, I wonder if there is single perennial river in entire Karbi Anglong, my lord. Now, your lordship will kindly come to page number 104. The heading is abstract of cost. Head work, including other appurtenant work, 3 crores, 72 lakhs, etc. My lord will kindly come to the next page. This is where 3 crore 72 lakhs has been spent at page 5. It's a, my lord, hardly, my lord, it will be about maybe 30 or 40 square feet by 20 square feet premises. Headwork of Dongmei Bay Gaon, 3 crore 72 lakhs. It's not a, my lord, perennial river. It's a pump whereby they are lifting water. It's a diesel pump. My lord, the contractor is the brother of the CEM, Chief Executive Member. His name is, my lord, Sarim, S-A-R-I-M, Sarim Ronghang, his brother of CM. For headwork, 2.99 crore has been paid to him. No river, only, but there is no river, but on the head of trimming, river trimming work, 50 lakh was paid. Now, in the affidavit in opposition, in the affidavit in opposition, my lord, their stand is, diesel pump installed. Yes. Huh? If your lordship would kindly come to page 14 of the affidavit, my lord.
Affidavit in opposition by whom?
By the, my lord, respondent number 5. 5. Sorry, 5 and 9. The Karbi Anglong Autonomous Council, my lord. At page 14, capital D, my lord. In respect of Dongmei, Mepi,
Respondent
Begaon,
number 2 and 9 replies there.
page 14, my lord. 12. It's an affidavit by respondent number, an affidavit in opposition on behalf of respondent number 5, Karbi Anglong Autonomous Council, and respondent number 9, additional chief engineer.
What is the running page number?
I think 252, no, like, either 252 or 254.
Why do you call it?
কোনটা number?
254,
254.
54. If your lordship would kindly come towards the bottom, D. In respect of Dongmei P,
Still we are searching.
actually, my lord, we made a mistake by not,
You're referring to affidavit in opposition by respondent number 2.
but in the copy which has been given to us,
22nd April 2019. Is that the one?
no, my lord, 5321. It's by respondent number 5 and 9. It is by Joybinon Long Malay. He is in fact the respondent number 9. He is the additional chief engineer.
Yes.
Has the lordship got it, Miller?
Yes.
Yes. May I have your lordship's kind attention to page 14, internal. D. In respect of Dongmepi Begaon irrigation scheme, the deponent begs to state that Dongmepi Begaon irrigation scheme was included under AIBP so-and-so with an estimated cost of rupees so-and-so to create potential area of 446 hectare. The category of scheme is tank irrigation, flow irrigation of which source is from water body is named as a tank. The work has been executed as per the provisions made in the estimate and progress of work was 100% and the scheme is physically completed in March 2016. It is clarified that irrigation scheme for supply of water to paddy field depend upon requirement of water to be supplied from the source of water. The sources may be river or stream or nala, pond or any other water bodies. The source of water of Dongmepi Begaon irrigation scheme is perennial, big size water body of approximate circumference is 3 kilometers. The maximum requirement of water during the lean period is only so-and-so cubic for the proposed crop. The said water body proposed to be discharged easily the maximum requirement of so-and-so without any breakup. After observing and taking hydraulic data, plan potential area, calculation of the cost benefit ratios per the guidelines of MI schemes, this scheme was found technically feasible and economically viable, and accordingly this minor scheme was taken up, which source of water is from water body named as a tank irrigation scheme. However, considering the urgent drought season in future due to insufficient rain, which perhaps may change weather as well as imbalance ecology, provision of diesel pump set is installed in a permanent pump house for lifting of water from the water body tank as and when required for supply of irrigation water to farmer. The main headwork of this scheme is constructed with a retaining wall for permanent storage of water in the water body to maintain the minimum water level to enable supply of water without any disruption. Due to heavy raining since so-and-so and on so-and-so, heavy flood occurred in the district and scheme was affected by flood and different components, efflux, guide band, protection works, etc. of this scheme were damaged. So in respect of each and every scheme, my lord, it is the flood who is the culprit. Money is going to contractors. there is no, I mean, difficulty. The explanation in each of, in the affidavit in respect of each of these scheme is the flood is causing Milord. Now, I have placed the, I mean, that DPR Milord, it speaks of perennial river. Where is it gone? Where is the money of 50 lakhs spent on, my lord, trimming of the river? So, my lord, this is one. Then, my lord, will kindly come to another scheme. If your lordship now takes the other, compilation at page number 10, my lord.
Yep, the main of what.
Page number 10. Project proposal for Langram, Lang Punky flow irrigation. This is also supposed to be flow irrigation scheme. Now, if your lordship would kindly come to page number 12. Before that, if your lordship would kindly come to page 11 on top. The main source of water is so-and-so river, which is perennial river. Now, if your lordship kindly comes to page 12, head work 1.44 crore and river trimming work with protection work 38 lakhs. Now, if your lordship kindly comes to page 13, these are the, my lord, photographs taken on 10th of July 2019. Kindly see in these channels, there is no water. Only when there is rain, there will be water, otherwise there is no rain. And at page 14, kindly see, my lord. This is the inspection by DCHA team on 14/3/19 and photograph taken following inspection, all dry. If there is no rainfall, then there is no water. Now, in respect of these also, my lord, in the affidavit, this stand is, this scheme was damaged by flood on 12/6/18 and components like efflux bund, protection work, canal lining was damaged badly by flood. Then there is another project that is Walling Disa irrigation scheme. This is at page number. At page 16 of the.
This first, this project which you are questioning.
Yes.
Is the name of?
The name is, my lord, Dongmepi. DONGMEPI. Dongmepi.
Dongmen.
Bay Gao flow. Supposed to be, my lord, this source is supposed to be a perennial river, both 1 and 2. A structure of about 40 feet by maybe 20 feet, where they have installed a pump.
Yes.
Then, my lord, will kindly come to page 16. This is Walling Disa irrigation scheme at page 16 of the compilation. Then it is also supposed to be a perennial river at page 17. The main source of water is Walling this a river, which is perennial river. Total length of the river is so and so, so and so. Now at page 18, my lord, the headwork cost is about 4 crore 82 lakhs and river trimming work is 72 lakhs. If your lordship would kindly come to page 20. This is the actual, my lord, state of affair. Walling this irrigation scheme 2014-15. Front side of the headwork, page 20. And these are the photographs which are relying, my lord. These are given by the respondent in their affidavit. Now kindly see the channels through which water is supposed to pass. Is all right. And the contractor is the, my lord, same person, brother of the CEM. That's Sarim Ronghang, brother of CM. And in the affidavit, same thing, my lord, scheme was damaged by flood. Now, my lord, this is how our allegations are. Now, there was a proceedings in this honorable court, my lord, at page 49 of this compilation. At page 49, there was an inquiry report pursuant to order of this honorable court, not in respect of these schemes which we have highlighted, my lord, but in respect of some other schemes. If your lordship would kindly come to page 49, inquiry report on Longsolite and Dilangkiri irrigation scheme under Karbi Anglong. The Honorable Guwahati High Court constituted a high power technical committee with nominated members of the government of Assam, by order dated so and so passed in PIL number so and asked to inquire if any financial irregularities are committed in implementation of the following schemes and submit opinion on the same after visiting the site and examining the records. Now, this is the background. Now, if your lordship would kindly come to page number 52, the views of the committee. Page 52. If your lordship would kindly come to 4, somewhere in the top middle. Headwork component of this scheme is not supported by structural and hydraulic design, either in original TS copy or in working estimate copy, implying that technology of this scheme was not assessed. Then, my lord, will kindly come to views of the committee. The techno-economy of these schemes were left unassessed as component dimensions are not supported by hydraulic and structural design detail in both the original and working estimate. Necessity of increasing depth of the core walls below ground level involving huge financial enhancement in both schemes without any soil test and design is lavish. As location of the work component have not been clearly indicated in index map of the sanction scheme, the committee found it difficult to verify the river trimming work in so and so. Quality and quantity of actually executed work are known to be not checked, measured by departmental quality control wing. Then this is very interesting. Non-production of records and documents stated to be destroyed in reported fire incident has prevented further inquiry process of examination on financial irregularities as below. So either flood will come to their rescue or some fire incident. Despite all this, my lord, at page 53, with all respect to these government officers, the last para of the report, however, the so executed headwork structures of the schemes are found existing and working at the site and supplying water to command area in so and so, so and so, so and so. So also in so and so, so inform that about 200 families and so and so villages are benefited from this scheme. My lord, when the committee could not assess what the work is all about, I do not know, my lord, on what basis this conclusion was drawn by the committee. Now I leave it to lordships to draw an appropriate, my lord, inference in the facts of the case. Now, on last occasion, lordships would recollect that the other side was referring to an order passed in the PIL, another PIL. Order. In their affidavit, my lord, they have annexed that order. I think it is at page number 371. It will be what is the difference between order? Yeah.
Non-completion.
And the main allegation in this PL, which the other side is relying, is, my lord, this is regarding non-completion of the work. If your lordship would kindly come to page 371.
Mr. Chaudhary,
Yes,
as far as regarding this report is concerned, which you are referring to,
yes.
of June 2017. That was already subject matter of one of the writ petition wherein the court has taken into consideration that and said, in view of this report of the committee, we are not inclined to pass any order further. Then you challenge it before the Supreme Court also. That also came to be negated. The liberty to file review petition has also been dismissed.
No, my lord, I'm not on that. What I'm saying,
The-
no. Factually, what your lordship has said is absolutely correct. Well, I'm not disputing that.
Yeah.
No, because they are relying on this order, that's why I have referred to it. I am on a different plan, my lord. Those are pertaining to some other work. These
Some
are
other-
some other work, not the allegations which are brought out in the present, PIL. And
Here-
secondly, my lord, the
Here-
allegations in this PIL was non-completion of the work.
Here you are referring to this report, which
No, no,
is.
I am not referring to the report, my lord. The report they have referred, they have brought on record. I am just pointing it out. They are relying on it. What I am trying to submit is, this report is neither here nor there. That was a report in respect of some other work. And we are alleging irregularities in respect of some other work. Now, I have already demonstrated, my lord, how the works were actually not performed, but the payments were made. Under these circumstances, my lord, we are praying that some inquiry should be conducted to find out who are these beneficiaries of these illegal activities of the, my lord, corporation. My lord, I'll just rely on one judgment of the Supreme Court, then I will conclude my argument, my lord. Please have 2022 4 SCC 764.
Yes.
Please come to me, Lord, paragraph 27. Whether the heading is res judicata and PILs. আমার এখন কি assistant মিলিয়ে লাগে para 27. There is a subheading, my lord, res judicata and PILs. Whether lordships got it? Yeah. Union government and SOVL have objected to the maintainability of the present writ petition and sought its dismissal at the threshold on the ground of res judicata. It has been contended that the relief sought in the petition overlap with the relief sought by the petitioners in earlier petition instituted by Mutton Mine Mazdoor Sangh, which was dismissed by 3-judge bench of this court on 10/12/12. The relief sought in the earlier petitions were so and so, to appoint a high power committee, etc., etc. So, my lord, it apparently an earlier litigation was dismissed. Now, please come to para 28. The petition was summarily dismissed by this court on 10/12/2012 in the following terms. We are not inclined to entertain the writ petition, which is accordingly dismissed. The present writ petition was filed seeking the following relief. Issue a writ of mandamus directing respondents 1 and 2 herein from disinvesting the residual shareholding of the government of India. This was the prayer, my lord. Then my lord will kindly come to para 32. The principles of res judicata and constructive res judicata, which section 11 of the Code of Civil Procedure embodies, have been applied to the exercise of jurisdiction, including public interest. Yet the courts have been circumspect in denying reliefs in matters of great public importance on a strict application of procedural rule. In rural interest litigation and entitlement Kendra versus so and so, this court observed the writ petition before us are not inter partes disputes and have been raised by a public interest litigation, and controversy before the court is as to whether social safety and for the creating a hazardless environment for the people to live in, mining in the area should be permitted or stopped. We may not be taken to have said that for public interest litigation, procedural laws do not apply. At the same time, it has to be remembered that every technicality in the procedural law is not available as a defense when a matter of grave public importance is for consideration before the court. Even if it is said that there was a final order, in a dispute of this type, it would be difficult to entertain the plea of res judicata. Then, my lord, this is how the Honorable Court proceeded. Then, if your lordships will kindly come to para 34. In state of Karnataka versus All India Manufacturer Organization, a 3-judge bench is also held that res judicata would be applicable to a public interest litigation if it was bona fide. As a matter of fact, in a public interest litigation, the petitioner is not hesitating his individual right, but he represents the public at large. As long as litigation is bona fide, a judgment in a previous public interest litigation would be a judgment in rem. It binds the public at large and bars any member of the public from coming forward before the court and raising any connected issue or an issue which has been raised or should have been raised on an earlier occasion by a public interest litigation. It cannot be doubted that the petitioner in so-and-so was acting bona fide. Further, we may note that as a retired chief engineer, Somasekhara Reddy had the special technical expertise to impugn the project on the grounds that he did so, and he cannot be dismissed as a busybody. Thus, we are satisfied in principle that Somasekhara Reddy, a public interest litigant, could bar the present litigation. Then, my lord will kindly come to para 35. While determining the applicability of the principle of res judicata under section 11 of the Code of Civil Procedure, the court must be conscious that grave issues of public interest are not lost in the woods merely because a petition was initially filed and dismissed without a substantial adjudication on merit. There is a trend of poorly pleaded public interest litigation being filed instantly following disclosure in media with a conscious intention to obtain a dismissal from the court and preclude genuine litigants from approaching the court in public interest. This court must be alive to the contemporary realities of abused public interest litigation and interpret the principles of res judicata or constructive res judicata in a manner which does not debar access to justice. Jurisdiction under Article 32 is a fundamental right in itself and of itself. So therefore, my lord, when it comes to a public interest litigation, application of principle of res judicata as the other side would like to contend. Supreme Court has not said that it will not apply, but considering
Sums
the,
up at para 36.
my lord,
The law has been summed up at para 36.
yes. In this case, since three judge bench of this court rejected the petition filed by so-and-so without a substantive adjudication on merits of their claim, present petition is not barred by res judicata. Yes. Correct. Yeah, because it was summarily dismissed. Now, in this case, my lord, at least there are prima facie materials to suggest that the money was not spent as they would like to say. After all, end of the day, my lord, this is public money. Would your lordships not like to know actually whether
Acha, Mr. Chaudhary, just as you are unfolding your case, there are a couple of aspects which are coming to our mind. You see, in implementing a public project,
yes,
there could be various types of malfeasance. There could be wrongdoings which are directly contrary to the law. There also could be wrongdoings which lie in the realm of governance. Now, the wrongdoings, let us assume that there are wrongdoings in this case, in the sense that projects have been drawn up without proper consultation, without proper material. Money has been spent in a manner which is against the public interest. Is there no mechanism within the governance system to rake up these issues? For example,
No.
is it not a matter which could be discussed in the assembly or in the floor of a house? Where
the irony is, who will, my lord, bail the cat? That is the whole difficulty. All are, my lord, of the same category. Who will bail the cat? My lord, we are seeing day in and out, things are going on unabated. My lord, that's why, my lord, when this institution of PIL developed in this country, initially, my lord, the idea was the downtrodden backward classes who are not in a position to project their grievances in the court, some public spirited person will take up their cause so that at least they get a justice. Over a period of time, my lord, now it is seen that there are genuine grievances of the citizens are not being addressed by the authority. Then where the citizen will go if the citizen do not come to the judiciary? Well, hundreds of letters were written to the authority. They are not acting on it. Where the citizens will go?
But those are only by the petitioner who himself is a contractor.
Maybe. Well, the fact that I am a contractor, that by itself will not take away my right to raise a public issue.
No, it will not take away your right.
Yes.
But the issue raised by a contractor.
Is it a case I am aggrieved by some action because my bill was not paid, so therefore I have come?
That's not the point, Mr.
Yes.
Chaudhary. We are trying to indicate that something else.
No, let me know. I have.
Because you are a contractor, that doesn't debar.
Huh.
But the court will be conscious of the
course,
fact
of course.
that you may also.
About my bona fide, the lordship will have to be satisfied.
Correct.
There can be no manner of doubt.
So any other member of the public has ever made a complaint?
Of course it is. No, it has been made. people are making. But the other people came, the other court dismissed, matter went to Supreme Court. Those are in respect of some other project. People are raising. And my lord, nowadays everybody cannot complain also. We are seeing in this country, my lord, how things are happening. I need not repeat all these things. Even if there are people who have got the right spirit, they will not go. Why will unnecessarily create a trouble? My lord, we know in this state, somebody wants to buy a property, initially an offer will be given. Thereafter, if the one does not agree, then he will be taken to police station from 6 o'clock to 8 o'clock, my lord. 1 month they will be kept waiting. One day he will say, all right, I'm selling my property at price to be fixed by you. These things are happening in this state. my lord.
They may be, there
Well,
are
I'm saying,
not,
no, my lord, no, lordship will kindly appreciate one thing. The allegations which are before lordships, are these not worth at least, my lord, inquiring about by some agency, whether what we are saying is right or not? We are on oath. We are on oath. If a lordship finds in the ultimate analysis that the petitioner has come up with a bona fide intention, please impose heavy cost. But if my allegations are correct, my lord, absolutely correct. There should be audit of everything. But is it happening in this country? Lordship will see, one fine morning, lordship will find all these street lights are being changed. Earlier street lights were working, or at least the bulb could have been changed. Because finance commission gives some grant, therefore might as well go for the whole thing. So we as a member of public, we can't say anything. We are seeing it day in and out. And this is not peculiar to this state, it is happening in the entire country. But should everyone be passive spectator to what all these things are happening?
No, that you may be right, but just because everyone need not be passive, is it for the judiciary to get into all
No,
aspects?
no. Question is, my lord, in a situation like this, where we are alleging that these illegalities are going on, where do we go? Or if your lordship feels that we should approach friends authority, we'll go. We can go. There's no difficulty. But who is that authority? At best, I can go to chief secretary of this state. There is no local person. Well, what I'm saying is, at least the allegations are prima facie serious. No, I appreciate, my lord. Normally, it's not the role of the judiciary. That is why the concept of judicial activism also developed, my lord. So therefore, it is said judicial activism coupled with judicial restraint is the order of the day. If your lordship, that way lordship is absolutely correct. Lordship has to be satisfied about my bona fide, whether what I'm espousing is correct or not. At least some report from the authority, my lord, why this is. My lord, is it believable that every time there is a flood, everything will get washed away? So there is nothing to inquire. Your records are destroyed in fire. You say it is a perennial river, it's not even a river. There is no flow. And you are putting up a pump for lifting water. So privacy, my lord, I think there are materials. So therefore, my only humble submission is, my lord, at least some inquiry at some level. What have you read to go? Page number. Page number, no, when I check it, I got page number. 205, 24.
Yeah, Mr. Chaudhary, anything else?
Yes, my lord, Lordship was inquiring about that complaint. Page number 151 of the petition, my lord, that was a complaint filed before the chief engineer, which has never been attended.
Yes.
Then, my lord, at page 192, CM Vigilance Cell was approached. Page 192. So therefore, these are my allegations, my lord. There are other allegations also. I have only indicated 3. Therefore, my humble submission is, my lord, subject to your lordships being satisfied, would order an inquiry at least to find out what is what. And merely because on an earlier occasion, in respect of some other project, more or less similar complaints were lodged. And my lord, the inquiry report I have shown, my lord. In that view of the fact, I'm not making any submission other than to say the discussion was something and conclusion was something. So therefore, my lord, at least some inquiry should be ordered, my lord. Let it be that the vigilance, CM vigilance, and also, make an inquiry. Let us find out, my lord. That is my humble submission. Lord, I'm awaiting a matter in court number 2 cases. Deeply.
That complaint is 191, which was in the form of an FIR to the CM Vigilance Cell. It was filed on 1/7/2017. So if this is a FIR, then there is a procedure under the CRPC, how to, if no action is taken, how it can be taken care of by invoking the provisions of section 154. They can go to the magistrate, they can go, finally they can come to the honorable court also if the investigation is not done. So they have just, for the sake, one document was filed before the CM Vigilance, and thereafter there is no statement regarding what actually happened. So we are not on that. And the other complaint which was lodged before the chief engineer, that is also very vague, few 3-4 lines, 154. So I do not like to make any comment. Regarding every scheme, the detailed photographs, detailed discussion, detailed inspection report, detailed monitoring report of the central agency, state agency are being annexed. For example, just now my learned friend read page number 254. But the most crucial lines my learned friend skipped. Up to flood he went. Page 255. 255, third line. So my friend stopped that. Due to heavy raining since the night of 12/6/2018 and on 5/8/2018, heavy flood occurred in the district of West Karbi Anglong and the schemes was affected by flood and different components. That is efflux and guide bands, protection work, canal lining, art canal structure, etc. of the scheme were damaged badly. So he stopped here. Going further now. Though the department has not found any fund for rejuvenation of the scheme damaged by flood, but the department has taken up repairment of required items of the work to enable to supply of irrigation waters to the farmers. The scheme is functioning and the farmers are getting benefits. This scheme was monitored and inspected by different agencies and are as follows. In March 2019, Team of Development Commissioner of Hill Areas Department, DHA, Government of Assam inspected. Identically all this, and for a moment, Lordship will kindly see the photographs at page 328. It's a 10 crores project. The work is very much visible here. 328. There is a sluice gate, there is a canal, concrete canal, water, everything. The inspection was done on 6th of July 2019. Dongmepi Bay Gaon irrigation scheme. Next page also. Lordship may see. So identically, all schemes photographs are there. Next page, Langhang Kapi irrigation. All these canals, the waters, the sluice gate on the top floor, photograph on the top on the left-hand side, there is a sluice bund. These are all minor irrigation schemes. If Lordship come to page, I'm taking all the photographs, then Borjan, 319 page number. The schemes which they have raised allegations, we have submitted the photographs here.
319 or 90?
319.
The allegations.
Allegation. The next page, the photographs. All these, just saying that no work is done, it's a very casual
19.
and irresponsible statement. The photograph speaks ultimately, Lordship. I'll come to the other aspects also, but let us see the photographs. Disobey, 325. All these photographs are there, Lordship. With the officials, Lordship can see the faces of these people also. Nobody will submit a document before this honorable court by morphing any photograph. Nobody will dare to do that. So the photographs speak much more than the words. So Walling Disa at last. Walling Disa, last page. So all these works are being done. And how these schemes are being executed, Lordship will kindly come to page paragraph 15 of my affidavit. Affidavit of respondent number 5 and 9. I'll take to various paragraphs, but let us first read 15, paragraph 15. May I read it, Lordship? The Accelerated Irrigation Benefits Program, AIBP, was initially launched by the Government of India in the year 1996-97 as a central assistance program for accelerating the large-scale irrigation projects. Subsequently, the scope of the programs were expanded to cover the minor irrigation scheme in special category states, which includes Assam. The AIBP guidelines lay down the eligibility criteria and norms for inclusion of the projects and schemes under AIBP. The projects with irrigation potential less than 200 hectares of cultural command area are categorized as minor irrigation scheme. AIBP provides for an elaborate framework for planning for implementation of MI schemes. In MI schemes, the planning process involves preparation of preliminary project reports, PPR, after conducting necessary survey and investigations. The PPR is required to be approved by the Technical Advisory Committee. The PPR are therefore submitted to the Central Water Commission, which scrutinize the same and accord in principle consent for preparation of detailed project reports, DPR. The DPR prepared by the authority are examined by the CWC and sent to the Ministry of Water Resources for clearance for inclusion of the schemes under AIBP to be eligible to receive central assistance fund. These are all central government affairs. The central assistance is in the form of central grant 90% and other 10% state shares. The AIBP schemes embodies about the funding pattern and the modes of disbursement of the fund. The funds under the schemes are to be released in installments. First installment, 50% of CA to be released after state releases its full share, that is 10%. Second installment of CA to be released after obtaining utilization certificate of minimum 50% of CA.
Now, what do you want to try to indicate or to convey?
What I want is that before release of the final amount, there is an inspection, proper inspection, utilization certificate. Then only the fund comes in is being paid. The authorities which they are alleging lordship, they're doing some mischief. They are not the authorities. The authorities are central government authorities and the state government authorities, and they have to monitor and submit report about the progress of the projects.
These minor irrigation schemes are partly centrally sponsored.
Yes, 90%. 10% state of Assam. Absolutely. And number two, lordship, not going to about his local standard. He was a regular contractor. He was doing the identical work, which I have stated in paragraph 12. May I read it? Paragraph 12.
Yes.
At the outset, the deponent begs to state that the garb of the public interest litigation, the petitioner wants to espouse his personal grievance against the Irrigation Department of Karbi Anglong Autonomous Council. The petitioner Mohan Rangpi was a registered contractor of Irrigation Department of Karbi Anglong Autonomous Council, Difu. His personal interest was obvious and entwined with the Irrigation Department of Karbi Anglong. Further, as per available records, the petitioner had executed different works of the irrigation schemes under the Irrigation Department. Out of all the irrigation schemes recorded in the name of petitioners in the record of the department, none of his works were satisfactory, and as such, he was not allotted any work since then. The petitioner concealed the material fact before the Honorable Court that the petitioner had executed different works of Irrigation Department under the Irrigation Department of Karbi Anglong Autonomous Council. The schemes were founded by AIBP, NEC, State Plan, etc. In the financial year 2013-14, the petitioner demanded to make the payment of 21,42,740 against the work executed by him. The department then inspected the work in the field and found that he did not execute some of the works and the works were not completed. But the petitioner threatened the site officers to prepare the bills for which the bills were prepared. That the Thekerajan irrigation scheme was sanctioned during the year so-and-so. The petitioner had failed to execute the work as per approved drawing, and due to poor quality of the work, the scheme has not been functioning. The farmers are not benefited for the failure of the petitioner to execute the work as per the specifications, though the petitioner received an amount of 39,60,000. The petitioner had demanded the payment of the balance amount, but due to non-payment of balance amount, the petitioner filed a present petition for his own interest. Next, paragraph 14. The petitioner received an amount of 3 crores, 33 lakhs, etc. till 2010 for execution of different schemes under AIBP, NLC, PR, NEC, State Plan, etc. And it is found that petitioner had failed to complete the work as per the specification, and for that reason, no work was allotted to him since the year 2010-11. The petitioner on the ground of RTI activists indulged in antisocial activities for which an FIR was lodged against the petitioner on 22/7/2016 by the Principal Secretary, Karbi Anglong Autonomous Council. This is an IS officer, Lordship, from the state, from the Indian Service. In Difu Police Station, registered as case number so-and-so.
But in that case, he has already been discharged.
Discharged, but he came for quashing of the FIR. This honorable court found substantial material. That order also I have annexed, Lordship. The IO after investigator filed a search sheet. So search sheet was filed. So there are a lot of situations in that ground reality. Nobody would dare to speak against a person in the court also. Those are other issues. So now how the scheme, everything has been, we have clearly mentioned, Lordship, how the monitoring is done, paragraph 17. The government of India issued the modified guidelines of AIBP schemes affecting from October 2013. Clause 5 of the guidelines stipulates about monitoring the scheme project. Clause 5.2.2 provides that the scheme could also be monitored sample basis at least 5% of MI schemes by the concerned regional office of Central Water Commission and will be assessed against the predetermined target set by the Ministry of Water Resources. Out of the 60 minor irrigation scheme of the year 2013-14, more than 5% of the schemes were monitored by the competent authority in various dates since January 2016 to March 2019. Similarly, out of 64 minor schemes of 2014-15, various schemes were monitored by the competent authority from January 2016 to November 2018. Next. We have annexed everything, the modified guidelines. Now coming to paragraph 18. The petitioner has alleged non-completion of 7 minor irrigations for the year 2013-14 and 14-15, out of which Disoba irrigation scheme was monitored by the Monitoring Appraisal Directorate, Guwahati, in January 2016. Subsequently, that scheme was again inspected and monitored by a team consisting of Chief Engineer, Brahmaputra and Barak Basin Organization, and Director of Monitoring and Appraisal, Guwahati, Central Water Commission, in September 2013, and submitted the report that the scheme is physically completed and the financial liability should be completed. The Borjan CIS was inspected and monitored by a team consisting of Chief Engineer, Brahmaputra and Barak Basin Organization, and Director of Monitoring and Appraisal, Guwahati, Central Water Commission, in September 2018. Third, the Long Parpan irrigation scheme was monitored by the Monitoring and Appraisal Directorate, Guwahati, in December 2017. Fourth, the Langarpur IS was again inspected and monitored by the team comprising of Chief Engineer, Brahmaputra and Barak Basin Organization, and Director of Monitoring and Appraisal, Guwahati, CWC, in September 2018, and submitted the reports, and the scheme is physically completed and financial liabilities should be completed. So we have given the monitoring reports also annexed as Annexure 11. Now, paragraph 19. In the instant, the petitioner alleged about the non-completion of 7 MI schemes, Borjan, Long Parpan, Disobai, Dongmepi, Lang Phangki, Waling Disa, Yaung Disa, minor irrigation. So we have given specifically everything. Each projects, we have given the complete report here. Everything. Now, taking the example of Borjan, number 1, the monitoring agencies very clearly says, the first inspection, June 2000, that is Team of Development, Commissioner of Hill Areas Department, Government of Assam. Then September 2013, 18, Chief Engineer, Brahmaputra and Barak Basin. Whatever we have stated, these are indicated in a chart. So all the schemes are working, the benefits are being there, photographs are there. After,
Mr. Saikya, in essence, what you are submitting is that there is a discrete mechanism.
absolutely, Lordship.
And there is nothing to show that there
Nothing
is
to show.
breach of that mechanism.
And if Lordship is pleased to, because the issue of res judicata, the first PIL, a high-powered committee was constituted by this honorable court. That order is, Lordship will find at page 266. The then my Lord Chief Justice Mr. Ajit Singh and my Lord Justice Manojit Bhuya passed that order on 24th August 2017. Lordship is pleased to come to 268. So we volunteered from our side that let the honorable court constituted a committee.
That way constituted, then the review petition
And
was
the
filed.
honorable court said that
SLP was filed, review
yes.
petition filed.
all 386 scheme was the subject matter here.
And here in 2019 also some PIL is there, then
These
Another-
same schemes were included there also, 3 rounds. Number one. And number two, this committee was comprised of the people of high moral values. This was the opinion of the honorable court that nominate what the honorable court said. In the fact situation, we are of the considered view that an opinion of independent high-powered committee is necessary. The state also fairly agrees to nominate 5 officers of impeccable integrity for independent high-powered technical committee. Even the learned counsel for the petitioner readily agreed for an independent opinion of such high-powered committee comprising of officers nominated by the state government. So this is how, and it went to the, because after receiving the opinion lordship from this committee, the honorable court was pleased to close the petition. It was not a summarily closed petition, just like the judgment which they were relying. It went to the Supreme Court. Supreme Court again sent back for review, and the review order is also passed here. The honorable court did not found anything contrary to the report. That order is at page 272 in the review order. Now, if lordship is pleased to take an affidavit filed by respondent number 9, additional affidavit. Yes. 520.
yes,
Page 520. Paragraph 5.
Yeah.
Paragraph 5. The deponent begs to state that the petitioner has alleged non-completion of 7 projects. The names are Borjan, Long Parpan, Desobai, Dongmepi, Long Funky, Waling Disha, and Yaung Disha. It is pertinent to mention that Desobai, Waling Disha, and Yaung Disha irrigation schemes has been specifically mentioned in PIL 37 of 2019, along with the 12 schemes of 2013-14 and 10 schemes of 2014-15. And the Long Parpan irrigation scheme has been specifically mentioned in PIL 55. So PIL 57, 37, 55, along with 54 irrigation schemes of 14-15 filed by Long Kumar Bay. The 15 irrigation schemes of 14-15 are specifically mentioned in Annexure J of the PIL 55 of 2019. In PIL 107 of 2000, that is the original case, the petitioner alleged non-completion of 386 schemes, which includes all the AIBP schemes till 2013-14. The 7 irrigation schemes mentioned by the petitioners are within the 386 schemes mentioned in PIL 107.
yes.
37, etc.
2-3 petitions.
Yes, now, on this basis, this honorable court passed an order because one authority has been indicated, that is the principal secretary, page 531. 8/3/2000. So here also, the third paragraph, one of the primary objections raised by the respondent is that regarding the same matter, another PL so-and-so was filed. So taking a cue from this raised litigate point was also taken. Then finally, the honorable court said, we make it very clear that in case the petitioners has some reports or evidence before him to suggest that the projects have not been completed, he would always be at liberty to approach the principal secretary, Karbi Anglong Autonomous Council, who shall verify the matter and pass appropriate orders therein. That is number one. The next order, another order, page 535. Here, reiteration of the earlier order. Then, my Lord Justice Shyam also was pleased to pass an order sitting with the then Chief Justice at page 540.
Yes,
16/3/2023. So there is a continuous practice now that if these schemes are included in 386 or subsequent PILs, but in this case, my humble submission is that this case is totally different from the other cases from the point of view, on the point of locus standi. Here he has a mala fide intention. He has a personal grievance. He has a personal interest. So it will not come under the domain of PIL. So therefore, in my humble submission, Lordship may be impose a exemplary cost on him.
Looking to his work quality, he was denied to, no work was assigned to him since 2010, and on account of that, now he has filed this petition.
And he involved some extremist organizations to threaten our officers, compel the principal secretary lodge an affair against him.
Yes.
This may be considered, Lordship. Highly obliged.
That's all. Yes.
Lordship, my senior have already argued. The only thing which I want to state is that the previous PILs were not about, were about non-completion. And the present PIL is not about non-completion.
It's
It
about
about there is,
completion and corruption.
it's about there is no potential in this thing.
Okay, we'll come.
Much obliged.
Deeply obliged.
Item 55,
Order is there. Yes.
Lordship, the appellant, his father died in harness,
Hmm.
and according to the age of the appellant, he was at that time minor. His father died in the year 2016. And her mother was also suffering from paralysis. Yet, on behalf of the minor, his mother applied before the inspector of school, Borbeta, on dated 9/2/2017. And it is later on found only the report of RTI. As the application was done by his mother, it was not with the in the hands of the appellant. And moreover, she was suffering. The first, when he applied, in the first instance, the respondent have not raised any objection that he have applied after the 1 year. But at that time, the respondent mentioned that there is no any vacant post. But later on, when his application was rejected, he preferred his honorable court, High Court. Then in the first instance in WPC, a order was passed that he may be appointed in the post of Group D or any other post. But at that time, the DLC, Borbeta district, they raised another slogan, another question, that he have not applied within 1 year. For the first instance, they mentioned that there is no any vacancy. The second time when he was directed by this court, honorable court, then they raised the question that he have not applied within 1 year. Thereafter, the appellant preferred the contempt case, but under some circumstances, he withdrew the contempt case and again filed another WPC when that was rejected, that he have attained the maturity, and but in this way, 3 years has gone, but he have not applied. The appellant applied in the year 2021. But his mother applied in the year 2017, within the period of 1 year. And it is in the clearly stated in the page number, RTI report.
Who is appearing with the respondents here?
Yes,
His page number 49,
yes,
the report in serial number 8.
yes,
Abul Kalam Azad, then his father died on 12/2/2016, and he applied 9/2/2017.
yes,
And the last para was applicant applied for the post of grade 4 DLC, could not recommend the proposal due to the want of vacancy post.
yes,
So he had applied within 1 year, and it was clearly stated by the report of the RTI, but the respondent, they mentioned that he have applied on (31/5/2017).
yes,
But the RTI report clearly shows that he have applied within 1 year. And only the arithmetical calculation, wrong calculation, and there's the official report concealed by the DLC. He has been suffering from this type of, already his father is died. Thereafter, his mother, who was suffering from paralysis, she also died. So there is no legal here except him in his family. So on the basis of this RTI report and any other report, that they have first time not raised question that he have not applied within 1 year. They have admitted that I have applied within 1 year. And second time, and then they stated that there is no vacancy. The second time they raised question that you have not applied within 1 year.
yes,
And thereafter that Honorable Court in WBC so and so again directed that he may be appointed. But then they raise question that you have not applied within 1 year.
yes,
And that is the impugn order. The second time in WBC that was rejected. So that on the basis of the first WBC and on the basis of the RTI report, he kindly may be directed to appoint by the respondent.
okay. That's all? That's all? That's all?
Uh,
Any other argument? These are your arguments?
Sufficient.
This writ appeal is filed by the appellant. Being agreed with the order dated 29/3/2023, passed by the learned single judge in writ petition number 1712/2023, whereby the writ petition filed by the appellant seeking with a prayer to direct the respondents to provide appointment to the petitioner on compassionate ground will stop. The learned single judge has observed that in the earlier writ petition preferred by the petitioner, this court while disposing the said writ petition has directed the respondents to consider the case of the appellant for providing an appointment on compassionate ground as per the clause 15 of the office memorandum. However, the memorandum, full stop, it is further observed that the concerned authorities has taken into consideration the case of the appellant and found that that he has not moved application within the prescribed period of 1 year, and therefore the same is liable to be dismissed. It is learned counsel, the learned single judge has observed that as the appellant has not applied for compassionate appointment within the stipulated time, the decision of the authorities concerned of rejecting his application is not liable to be interfered with. Full stop. Learned counsel for the appellant has argued on length to justify that there was no delay on the part of the appellant because the first application filed by him was within limitation. Be that as it may, within the limitation period, full stop. Be that as it may, it is not in dispute that father of the appellant died in harness way back in the year 2016. Full stop. It is settled that the scheme for providing compassionate appointment to the dependents of a deceased employee is be that as it may, again. It is be that as it may. It is not in dispute that the father of the appellant died in harness in the year 2016. Full stop. The object of the scheme of giving appointment on compassionate ground is to give immediate relief to the family members of the deceased employee. Full stop. Who deceased employee who are facing financial crisis. Full stop. However, in the present case, the father of the appellant died in the year 2018, and the appellant and his family members have survived. Till this date of employment by the state, the family of the appellant as well as his family has already overcome the financial crisis which they financial crisis. Hence, in such circumstances also, we are not inclined to interfere in this matter. Hence, this writ appeal is dismissed.
My lord, I am applying for respond number 1, 2, 3, 4, my lord. They are not, my lord.
So, do you have any objection to that?
My lord, we require because now
What they are seeking that those people that CPWD has expressed its inability to get
Malak,
the
as regard
commission report.
as regard to that, already the measurement has been done, but the CPWD assessment report has already been submitted, my lord. In this writ appeal, my lord, in the review petition.
Well, let me explain, my lords. Quick, story is twisted. Initially, my lord, arbitrator state everything.
I think it's one of the matters.
Yes.
we have-
Yes, my lord,
Yes, my lord.
lordship had clarified. In that each case, my lord, what had happened, CPW did something. They half-heartedly, my lord, they complied with it. But in this case, my lord, I'll let me, my lord. In what had happened, my lord, in the light of the direction passed in this order, my lord, some other writ petition was disposed of. My lord, I will go to that order, my lord. It starts at page 52.
Yeah,
And the operative portion, my lords, everything is similar, my lords. Operative portion is at 57.
yeah.
Here, what had happened, my lord, the issue of CPWD was indicated to the court that CPW has expressed its inability. CPW cannot do it. But one issue also could not be pointed out that the income tax department, my lords, why its my lord communication.
But in this order dated 28/9/2023, that was not there. Income tax department is not there.
My lord, it was
The
the,
order
My lord.
dated 28/9/2023, of which you are seeking review,
my
it
lord.
nowhere speaks about this income tax officer. It simply says in view of the peculiar facts narrated above, it is hereby
Well,
directed.
my only impediment I face, my lord, since it says since the division or order of the division bench is holding field, my lord.
Huh?
The order speaks for itself, my lord. It says, my lord, the order of the division bench is holding the field. That very paragraph, my lord, paragraph at page 57, my lord.
The matter based on covered by the earlier division bench, however, Mr. Talukdar, some of the valuation, CPWD expresses ability to carry out the be that it is known, since there is already a division bench holding the field, the order would not have been complied with by all concerned in view of the facts and circumstances. But the writ petition will disclose providing 4 weeks time today for assessment of building shall be carried out by the valuation of the income tax Akar Bhavan. So far as the trees, plant, concerned, already been carried out. Therefore, subject to the fulfillment of the interim order passed by the London group, would then vacate the permission of the. So, this order, what do you mean by this order?
But since, my lord, it took cue from this division bench order, my lords, I would pray, my lord, lordship, the review order, if lordship is going to allow my petition, my lords, that this review, this order, writ petition order may be only, or writ appeal order may be confined only to the effects of the case of these Illavadis case, my lords.
This writ appeal order, how can we make comment on, you are not seeking review of this order?
My lords, since the runner single judge, my lords, took a cue from this writ appeal order, my lords, and passed the order, my lord.
How it matters, sir?
My
How
lord,
it matters?
my lord, it matters, my lord, because if I go to review, my lord, I'll be advised back to come to the division bench and seek a clarification.
Sir, division bench passed this order in relation to one specific case, not in general.
My lords,
So how the division bench order will come into the place, sir? No, sir, this is not the ground for, in this matter, the evaluation
Yes, my
part
lord.
is already complete.
that is government, that is done, my lord.
So then why-
And
why-
in fact, my
why-
lord, one was not pointed out, my lord, one page was not pointed out. That the CPWD minutes today communication before this order was passed, my lords, this
Yeah.
28/9, that expresses inability that we did,
But despite that, now they have done it.
no, my lords.
In this matter.
In this.
In this, it is done. In this, it is done.
So
Yes.
it's okay. We are not concerned.
Yeah.
We
And
can-
my lord, even CPWD, lordship will kindly be.
You may raise this point in appropriate proceedings, not in these proceedings.
My lord, that
So
observation.
that is,
My lord, that limited observation,
sir, limited observation. There is the question of giving any observation on this point.
my lord,
Mr. Counsel,
my
Mr.
lord,
Gogoi,
my lord.
please, this order is not in rem. This order is in relation to a particular controversy raised before.
Exactly, that
in
is my-
relation to one particular
Yes.
property. That's all.
Exactly, that is my prayer, my lords.
Yeah.
Your lordship just clarifies that, my lord, that sentence, my
Very
lord.
well, anytime if such question is arose, then you please.
That sentence will take care of
No,
all my
that-
anxiety, my
that-
lords.
No, sorry.
My lords.
In view of the fact that pursuant to the direction given by this court in the order dated 28th of September 2023 in writ appeal number 375/2023, CPWD has already carried out the inspection and submitted its valuation report in respect of the property in question. We don't find any case for review this said order. Hence this review petition is dismissed.
My lord, that will do, my lords.
That's all.
No, that sentence, my lord, that will do. That will do, my lord. Obvious, my lords.